Hi, everyone. Thanks for joining our call. We wanted to talk through recent changes that we're seeing for H-1B prevailing wages. So I've got a roadmap for today's call. We're going to hit five different things for our call today. We're going to talk about prevailing wage basics just to kind of set a foundation here. And we're going to cover new prevailing wage issues that we're seeing on the I-129 forms. And then we're going to cover prevailing wage enforcement. This is also a current trend that we're seeing that has picked up significantly in the last 3 to 4 months. And we're going to talk about prevailing wage changes. These are specific to the wage rates. And then lastly, we're going to hit recommendations from LBL for how we move forward and how we deal with these changes. So let's dive into this with the foundation for prevailing wages. So prevailing wages, many of you will already be familiar, but for those who aren't, we use prevailing wages for a lot of different uses. For the purposes of this call, we're going to focus on prevailing wages where it's used for H-1B lottery filings, every single H-1B filing, perm and green card applications. But prevailing wages are also used outside of immigration, and then inside immigration, they're used for things like E3 visas, H-2A, H-2B visas. So this has anything with prevailing wage, it's wide reaching and has big changes when these are adjusted or the government decides to put their finger on the scale as they've decided to do over the last couple of years. So they've long used a four-tiered prevailing wage approach for the prevailing wage that they publish every single year. These four levels are ascribed to entry-level positions, a higher wage, level 2 for qualified positions. The wages get higher for level 3 and then level 4. And in this, the one thing that I will mention as well is that the current government goal would appear to be to try and focus all prevailing wages, or at least the vast majority, meaning 80% of prevailing wages, into level 4 wages. This is something that we saw in the first Trump administration, and now we're seeing it again in the second administration. So on the I-129, so if you filed H-1Bs in the last 30 to 60 days, you're already starting to run into this issue. So the excerpts here are from the I-129 form edition that was published at the end of February and is now mandatory. It was implemented immediately online. So for any online petitions, this was implemented right away. For the paper filings, it was mandatory from April 1st. So these big changes are one, to align. Originally, this was laid out to align with the H-1B lottery selections, which in my opinion is more like a raffle. So you can see on the right side there on page 22, they're wanting to verify what wage level did you put into your CAP registration. On the left side, these are to calculate what is the appropriate wage level that should be used. And so because of where this is inserted in the I-129, it's easy to take this for granted because it seems like just information, but it's not. So, and this is actually USCIS working to get jurisdiction over prevailing wages so that they can substantiate the enforcements that they've already been doing. So historically, Congress gave the Department of Labor jurisdiction over prevailing wages and over setting prevailing wages and making occupation determinations and things like this. USCIS is charged with customer service side of adjudicating these petitions. And other than making sure that the LCA corresponds to the position being offered, they haven't been ever tasked with policing whether or not the LCA is appropriate in all respects. With this change, though, USCIS is taking jurisdiction over this because now when you're signing the I-129 form, you're attesting that these are the position requirements and these boxes directly correspond to the wage level calculation Department of Labor wants you to use. So each of these boxes that you see on the screen here, it starts with the prevailing wage rate, which we've seen in a long time. But then number 7, what's the level of education that's required? And then number 9, how many years of experience? Number 10, special skills that are required. number 11, how many people will the beneficiary supervise and what are their position titles? In a simple version, any entry to any of those fields results in one wage level tick. So if you answer all 4 boxes with requirements, you're at a mandatory level 4 position. So this is a big change, and it's easy to get confused between position requirements and the beneficiary qualifications. But this particular section and these changes are targeted for the position, not for beneficiary requirements. And the important thing to understand is that these requirements now have a price tag. Our next issue here, current prevailing wage enforcement issues. So this still relates right back to prevailing wage stuff, and we wanted to get you current on what we're seeing. So we're seeing consistent and uniform enforcement and verifications for every single H-1B petition that is filed. Now this meaning if you file an H-1B, they are going to conduct this enforcement verification. It's not if anymore, it's when. And timeframes are varying between 6 to 7 months, but on average, this is being done in the first 30 to 45 days after a petition is filed. What this looks like is they reach out to the individual, the beneficiary of the petition, they reach out to the petitioning employer, and they also reach out to any end client or customer that's involved in the placement. And they do this either simultaneously or nearly so. On occasion, they've got to request the contact details for the customer or the client from either the petitioning employer or the beneficiary. Most often, it's from the beneficiary. But most of the time, they already have these points of contact at these organizations, and they reach out directly. And they're reaching out with a variety of questions, but the specific questions that they're asking directly correspond to those 5 questions on the I-129 from the previous screen. What education is required? What years of experience are required? Are there any special skills? And does this position supervise other people? And this is targeted specifically to invalidate the I-129 petition and the labor condition application if all of these answers are not consistent and directly aligned with the LCA petition. The risk here is pretty big because anytime they find these inconsistencies, they automatically assume that there's fraud and that there's misrepresentation. And that's a big, heavy-handed tool that's very difficult to navigate because if you lose the petition, no longer do you just lose the petition. You potentially get blacklisted, but because this also involves a labor condition application, it can lead to issues with the Department of Labor as well. So what does compliance look like on this one? So first, all parties involved have to be on the same page for the details of the petition and for position requirements. So this means your employee, all points of contact within the petitioning company. So that could be HR, could be CEO, could be the direct manager. Anybody who's talking to USCIS has to be aligned. And then it includes your middle vendors and your end users. Good communication is, of course, the biggest key here, as well as notification to all parties involved. And that is because it's, as I mentioned earlier, it's not if USCIS contacts anymore, it's when. And it can be USCIS, it can be the Department of State, or it can be the DOL. And so having these conversations at the front end when you're choosing these prevailing wages is going to be a critical point to make sure that issues don't arise later. So now to our third point here, we want to talk about prevailing wage changes. So and these are specific to an update the Department of Labor published on March 26th. And this update informed the public that they were publishing a new rule to create a new regulation that would adjust the prevailing wage rates. But before we get to that, let's talk a little bit about the history of where this is coming from, what we've already seen. If you've been interacting with immigration for any length of time, you may already be familiar with some of these issues. And I'm hopeful that that builds some optimism for you, as it does for us, because we've navigated stuff like this before. Immigrants and the immigration community were a resilient bunch. So we'll navigate this and we'll find solutions, as we always do. So To lay this foundation, in 2020, the Department of Labor issued a temporary final rule aimed at significantly increasing prevailing wage levels for the H-1B program. That was their stated goal, but as I mentioned at the onset, prevailing wages are used across multiple other programs. So that proposal and implementation, because in that case they published this as a temporary rule, but that means they rolled it out immediately and made it effective to everybody. And what that did, so you'll hear terms in this foundational section like the 17th percentile, the 45th percentile, the 95th percentiles. So it's easy to just dismiss those as numbers, but when I want to kind of apply this to let you know what this translates to. And this translates to direct dollar figures. So when as far as the percentages, this is talking about, okay, so if you have an occupation and you're polling the wages within that occupation, you're going to get a huge range. And so they look at people at the top end, that would be the 100th percentile. You look at people at the low end, and then they find a space within this to establish levels 1, 2, 3, and 4. So our current system, as of today, and as it has been for many years, is level 1 is the 17th percentile. Level 4 would be the 67th percentile. What we saw in 2020, they moved this to where level 1 was the 45th and level 4 was the 95th percentile. That translated to an increase of about $40,000 to $50,000 between the 17th and the 45th percentile. And it quickly became untenable. Then later in 2021, we had an adjustment to this that lowered level 1 somewhat, only by about 10 percentile points, which translated to a reduction of about $5,000 or $6,000. And then these two rules and the implementation of it was challenged in court, and they were overturned because of these legal challenges. And it reverted back to the 17th percentile for level 1, 67th percentile for level 4. So meaning it reverted back to what we'd always known. Now, if you're tracking wage rates, inflation has played a huge factor in this. And so these wages year over year, they're updated on July 1st of every year. These wages have already increased significantly over just the last 18 months. And historically, they've had a very direct upward climb since 2020. This brings us now to the present. So March 26th, as I mentioned, March 26th of 2026, the DOL proposed this major increase again. And they published this as a proposed final rule following the rulemaking procedure that allows them to implement a regulation as long as that is consistent with congressional intent. This rule, so anytime a rule is published, it takes effect within 60 days, or it can take effect as soon as 60 days. And the purpose of that 60 days is to allow the public to post notice and comment to the proposed rule. So I would encourage everybody on this call, go and submit some comments. There are a lot of sources out there with pre-written templates, so you can provide feedback to let the Department of Labor know this is not realistic. It's unfair to the public. It's unfair to American citizens. And it has a negative impact on the job industry. But if you're interested in that, I would certainly encourage it. You can go look that up on the Department of Labor website. You'll find it under the news alerts, and we'll probably send a link out for this as well. So these proposed changes would only affect prevailing wage determinations or applications that use prevailing wages after the rule takes effect. So the soonest that would be, and we fully expect it to take effect on that first day, but the soonest that would be May 25th, 2026. So, and as of that day, I'll cover this in just a minute, but we expect the prevailing wage rates to increase significantly. Any previously approved prevailing wage determinations, labor permanent certifications or PERMs, or LCAs that are filed and approved before this rule implements will have the current wages, not the new wages. So it won't be retroactive to anything that's already approved, but anything that is pending when this rule is implemented that requests a prevailing wage will be affected. So, and to be clear, we do not expect that to affect any perm application that is pending as long as it's filed before May 25th. Any application filed after that could have an impact or adjustment. So their prevailing wage rates would result in a significant increase across all percentage wage tiers. So they're moving this, according to their rule, they're moving level 1 from 17th to 34th percentile. That translates to anything from $8,000 to $15,000, depending on your area. And as you can see from this chart, your level 1 is what was previously level 2. And your level 2 will now be what your level 3 used to be, essentially. And then your level 4 is going to be at almost the 90th percentile. And that's one of the bigger jumps, the biggest jumps that we're seeing here is at the level 3 percentile. And then this will affect H-1Bs, H-1B1s, E3 programs, perm certification cases in the EB2 and EB3. Anything that involves the prevailing wages will be affected. The one impact with this that feels especially unfair is that the new H-1B lottery system included prevailing wage rates. So if you submitted an H-1B registration in March, you committed to filing a level 1, level 2, level 3, level 4. And at the time, you would have committed to a specific wage rate within this 17th to 67th percentile. And everybody that did this looked up the wages, found a place they were okay with both position requirements, but also with the wage that was required. And now, starting from May 25th, whatever you calculated is now going to be $8,000 to $15,000 more expensive than it was when you submitted it. Recommendations from us. And so first, let's cover the impact of the changes to what we do every day. So as I just mentioned, this is a significant impact to selected cap cases. If you have an H-1B that's selected, you have from April 1st of 2026 until June 30th of 2026 in which to file the petition. And this increase of $8,000 to $15,000 is a big impact to any selected case. Our office has rolled out a new questionnaire for initiating any cases. And this is to address the I-129 changes because we can't answer those questions on your behalf. Our office can't determine position requirements. We need that information from you. The other impact here is alignment with your customer client requirements. So this is a key piece, as I mentioned, for compliance. It's also a key piece for any new filings. We need this alignment before we file so that we get these details correct and accurate, and so that issues don't arise later. The other impact of the changes here is it heightens the critical nature of communication between the employee, clients, customer, and the employer. This is because the USCIS verifications that are happening, as well as a common misunderstanding that these requirements are not about individual qualifications. They are or individual career achievement. These questions on the I-129 are about the qualifications necessary for any applicant to perform the job. And then lastly, understanding how the requirements and your answers move you up the scale. And as I mentioned, the goal here is very clear. The government wants H-1Bs to be highly compensated. They've used that term in press releases. They want H-1B positions paid more than anybody else in the country. And so their goal and their actions demonstrate a goal to move every petition, or at least the majority of them, to wage level 4 wherever possible. So what recommendations do we have from our office specific to our filings? So first, with H-1B cap cases, we're recommending that if you have a selected case, that you move up your filing if at all possible and try and submit and file your H-1B cap petition before May 15th. So if you've got a selected case, write that date down, get it on your radar, initiate and try and file an H-1B case before the 15th of May. That will let you take full advantage of the lower prevailing wage rate. And a certified LCA is good for a 3-year time window. So if you can successfully secure a labor condition application before this new rule is implemented, that wage rate would be good for 3 years. And so at $8,000 to $15,000 a year, you're potentially looking at a savings of around $30,000 over 3 years. So look at May 15th and try and initiate and get your cases filed before May 15th if at all possible. And keep in mind the importance of that date. A labor condition application takes 7 to 8 days to be certified and approved. So you'll want to plan for that, and we have planned for that with this 15th of May date. So get your intake forms back to LBL so that we can get your case filed before the 15th and support that for you. The 15th of May, that is. H-1B extensions. So we've already implemented some changes in our office where we're moving up filings and securing the labor condition application sooner than we usually would. So you can file an H-1B petition 6 months before the expiration date. Historically, we would align a labor condition application time period, so it's good for a maximum of 3 years. We would align that time period with the needed time period for the H-1B extension. So for example, if your H-1B expires, or if the H-1B expired on October 1st, the soonest we would initiate a labor condition application would be April 1st, because then we can request something 6 months in the future, and we'd cover the full time period from October 1st of, say, 2026 until September 30th of 2029. And so we would look at April 1st as the first opportunity to initiate those extensions. And best practices have always been to initiate somewhere between the 6 and 4 month mark wherever possible. That minimizes your need to file for premium processing. Our recommendation here is to take a look at any existing employees that have an expiration date in the next year and consider at least filing a labor condition application for them before the 15th of May. Possibly even pursuing the H-1B extension, though, before that date as well, even though that may mean tweaks to your petition, or in the case of, you might lose 6 months of time on a labor condition application. But that's a small price to pay compared against the $30,000 over 3 years that you might pay or might be required to pay in additional wages. Perms and prevailing wage determinations. So prevailing wage determinations are usually issued and they're only good until June 30th of each year. Unfortunately, because this is a 60-day rulemaking procedure, we don't have the option to get many prevailing wages certified before this rule takes effect. And that's what would be required to get the lower wages. We would need them to be certified. On average, prevailing wage determinations are taking between 3 and 4 months right now. So even if they were initiated on March 26th, it's unlikely that we're going to catch those dates. That said, there's still strategies that we can employ, including using prevailing wage determinations that have already been issued. Prevailing wage determinations, even if they expire on June 30th, are still potentially good for 180 days to support a perm filing. They're potentially good for 180 days after the expiration date, as long as this is done properly and there's careful attention to detail. Well, those are our recommendations for what we're seeing right now and actions that you can take immediately. That does bring us to the end of our presentation. We've got a QR code here where if you want to talk through issues here specific to your case, you can scan this QR code. You can go book an appointment with us directly from that link, and we can talk through any of the specific issues that affect you, either individually or affect your company. And as always, we're here to support you with your questions, so feel free to send those over. There's also an email address here. If you don't have an email for us already, feel free to take that down and send us an email with your questions or feedback. We welcome the chance to hear from you and to support you with your immigration needs. Thank you all for joining the call. Have a good rest of your day.